So welcome everybody. It's a small, cozy group this evening. It is July, and we know that lots of people are either away or enjoying the summer evening, and hopefully they will catch up with this final webinar in our webinar series on our website as a the recorded version. So you're welcome. The topic this evening is reporting abuse at crimes in personal support services. And just the background. Again, if you're coming to the recorded version and you're not familiar with the series that we have or who we are, we're Communication Disabilities Access Canada. We're a nonprofit, Canada-wide organization founded in 2001, which is a long time ago. We promote human rights, accessibility, and inclusion for people who have speech and language disabilities. And I use that term rather than communication disabilities because people outside of communication disability field think sign language and braille and accessible websites when I say communication disabilities. So we say speech and language to be clear about who we're talking about here. And of course, we include people who use augmentative and alternative communication. We do a number of different projects and we work on projects only. So we don't have core funding. We're always looking for projects that fit our mandate. And then what we do is research, development, and resources. And we share all of our resources for free on our website. So if you're not familiar with us, please go to the website and check us out. We are a group of speech language pathologists, augmentative communication clinicians, legal professionals, accessibility consultants, and we always include people with speech and language disabilities. And that's our website. I see other people coming on. You're very welcome to the webinar this evening. This webinar is funded through the Law Foundation of Ontario, and they have a connection with CLEO, which is Community Legal Education Ontario, and that's the group that fund this, called Connecting Communities. We're solely responsible for the content, but the focus of this webinar is legal information to people who support people who have speech and language disabilities. I want to remind you, as I do with all of the webinars, that our participants are a very, very diverse group, mainly speech and language pathologists, but we've had a lot of people who have communication or speech and language disabilities attend these webinars. We've also had people who are healthcare providers and who don't know as much about the population. We've had lawyers and students and social workers come to these sessions. So these are the right participants. These are the sectors that we want to engage in these discussions. But we're all coming to the topic from different perspectives. So be aware that we may be saying stuff that you already know very, very well, but we're saying it for the benefit of others. And hopefully we'll be able to fill in some of your blind spots as well. Presenters this evening, I'm delighted that we have Pamela Cross with us this evening, and I've worked with Pamela for a number of years. And Pamela, I'll let you introduce yourself.
Sure. Hi, everybody. I'm really happy to be with you tonight. I'm a lawyer, and as Barbara has said, I've worked with CDAC for a number of years, looking at some of the issues that come up in terms of accessibility from a legal perspective, access to meetings with lawyers, court appearances. I've been involved in developing and delivering some training for legal professionals. The bigger hat that I wear in my life is working on the issue of violence against women. Many similar issues in terms of accessibility. So there's a real crossover between those two areas of work.
Thank you, Pamela. It's great to have you on this webinar. Megan, can you introduce yourself?
Hello, my name is Megan Hens. I'm an occupational therapist and I work with young people with chronic health conditions. But my background prior to that was working with young adults with a variety of disabilities, helping them move out of their parents' home and transition into living into community settings.
Great. And Megan, you've worked with CDAC on a few projects in the past. We're delighted to have you. I'm Barbara Collier. I'm the Executive Director of CDAC, and my background is in speech language pathology and augmentative communication. And I've been really focused on project management, accessibility and inclusion, access to justice for people with speech and language disabilities since CDAC started in 2001. So I don't work clinically anymore. I just don't have time to do everything. But that's my background. In this series, and this is the last one in our series, it's focused on legal information and the population that we support, speech and language people with speech and language disabilities. We're archived all of our webinars, and I just want to draw your attention to them and make sure that you share this with your colleagues who may be interested in hearing them. The first one was on access to goods and services. The second one on consent to treatment. The third one on substitute decision making. And the last one we did was on personal support services. So really balancing, here are the legal issues, here's the law, and here are some of the communication resources to support people to negotiate and communicate about their rights in those settings. And I believe, well, I know that Megan and I are presenting at the ISAC conference I'll be presenting on access to goods and services, and Megan and I are presenting on capacity to consent to treatment. So if you want more, that's where we'll be if you're coming to the conference. Today's agenda is an overview of abuse, neglect, and crimes. We want to talk about reporting abuse. We want to talk about accessing legal and justice services, and the whole issue of connecting the dots on communication accommodations and supports within legal and justice services. This is, I have to say, this is an enormous issue. We could spend days on each one of these topics. We've got an hour, so we're trying to give you a bit of an overview on this and a flavor for the topics, and then you can go on our website, get more information, or connect up with us around the communication intermediary trainings. As with all of these webinars, we're really saying we're starting the conversation with you. We're not ending it, we're starting it, we're bringing up the issues. I'll say up front, if there are people on the webinar participating and you're experiencing abuse, we would suggest that you contact Arch Disability Centre and that's in Ontario. And we've given you the email address. We'll be sending out the handouts tomorrow where you can have that. And although they won't provide direct service, they may be able to help you connect you with somebody who can assist you. Just to give you a little bit of background then as to what we're talking about, abuse in terms of people who have speech and language disabilities. First of all, we know from the work that we've done, we did a 4-year project on this way when we started CDAC. It was our very first project. We focused in on abuse and crimes. And what we learned from that has been reported in the literature. People with speech and language disabilities can experience all types of abuse, and that includes neglect, physical abuse, mental, emotional abuse, financial and sexual abuse. And we often think about abuse as somebody, hurting one's body, but it also includes the issues of neglect, harassment, saying mean things to people, stealing. And someone can be abusive if they withhold food, medication, if they threaten to hurt somebody, if they just threaten to hurt someone or their pet or whatever. It's a much, much bigger issue. than just physical abuse or sexual abuse. So we wanted to broaden that out. And what we found also is that people with speech and language disabilities, they tell us that the main, even while they experience all of this, more than anything, they experience a violation of their rights in terms of freedom of expression, autonomy over life decisions, making and we talked about this in our other webinars about consent to treatment, having their own choices and communicating that. So abuse in a much broader sense. And I think it's important for us to know that all abuse is wrong. All of it is unacceptable. Not all of it is criminal, but all of it is unacceptable and wrong. What we know from the literature, and Dick Salvsey did some work in this area, and we know that people with disabilities can be 2 to 6 times more likely to suffer abuse and crimes. And that's people with disabilities. That is not talking about people who have speech and language disabilities. But I think it's a fair assumption to make that perhaps people who are perceived not to be able to tell are at even higher risk because of their communication disability. And we don't have any stats on that. It's impossible to get these stats. We do know that in general abuse increases with the degree of disability, which is sort of shocking. So you're talking about people who have more severe disabilities being more vulnerable, but also people who have multiple disabilities are more vulnerable. And that abuse is likely to be repeated. It's not a one-shot deal, it's repeated. And the offenders are very often known to the victims and are in positions of trust, sometimes in the caregiving context itself. David Hinsberger said something interesting recently. He said, people with disabilities are safer on the street than they are in their own homes. And I think that that's very true. If you think about the number of caregivers that go in and out of a person's life, have access to their bodies, to their personal space, to their things, and can close the door. So it's a very vulnerable situation. It's compounded by isolation. And we know that people with speech and language disabilities can often be socially isolated, have reduced social networks and supports around them. We know that it's compounded by the increase in reliance on these support services and caregivers, by poverty. We know most of the people that we support are on social assistance, and the inaccessible services in terms of police and justice. So offenders know that, and victims who have speech and language disabilities are well aware that they may not be able to access the police or even the manager of the group home or the residence they live in to make a complaint. They may not be believed, they may not be understood, they don't have the supports to do that. So we're talking about a population that really needs access to legal and justice services, perhaps more than anyone else, and has so many challenges in accessing those services. And those challenges include, and I see the list of people who are on this webinar, and I know I'm preaching to the choir here. However, for people who don't know, or just to have a refresher on this, tremendous fear of reprisal from the accused person or other staff members. I was involved with a case where a man did come forward and I assisted him to disclose to the police. Yes, the accused was what's the word? I'm searching for the word, but was taken off his work schedule. But the other staff heard about it, and it was a very, very uncomfortable situation for the victim. People with speech and language disabilities are often afraid to report because they're afraid of what will happen to their services. Will they be cut off? If they report something at home with a family member or an attendant coming into their home, does that mean that they will end up in an institution? Will their services be cut off completely? It's a very scary situation. In addition, they may not know who to tell or what to do, um, whether or even know their rights. Is this a crime or is it rudeness? Is the staff person who's being mean to me just rude? Is the staff person right? Can I expect the staff person to do more than they're doing? Can I um, I'm concerned that the staff person is borrowing things and not giving them back. Is that stealing or is it borrowing? It's all of those issues. Very, very fragile situations. What to do, who to talk to, who to communicate about, where to get some advice on this. And then compound that with the fact that people don't have the vocabulary to communicate what happened or what is happening. Very often, communication displays and devices don't have the vocabulary that is required to explain or to give those disclosures or evidence. There's no communication supports to assist with communication. It may be that one has to rely on a family member or a friend. It may be that the police or the legal person wants an arm's length person. Where do you get an arm's length person who's impartial to assist with communication? And then you get into that whole area of people assisting with communication and really not assisting, really speaking for and making huge assumptions. And the police, legal professional, justice professional not picking up on that, not knowing the difference between professional communication support and communication assistance, which is questionable. I've mentioned that there are inaccessible social, legal, and justice services. And we talked in the other webinars about just a lack of protocol and the need for protocol, distinct protocols that have to be customized for people whose disability is communication, speech, and language disabilities, and the complete lack of those protocols in place. I'll be telling you towards the end of the webinar what CDAC is doing or what we're hoping to do in terms of that. We know of stories of people who've not been believed. So they've gone to the police, they've tried to communicate. They've actually communicated their message and they've not been believed. Their case has been dismissed as being unimportant, as being exaggerated. And all of this is happening in a context where there's no alternative services and housing. There's no shelters. Pamela, I know you come from working with a sector where you talk about accessible shelters for abused women and families and children. We've got a situation here where people cannot just easily uproot and go to a shelter and have their attendant services and people who can understand them and all of that. The services don't follow them into shelters, which is a major concern. That was sort of just a very quick overview of very, very complicated situations. But I'd like to bring in Megan at this point, who's going to talk about the whole issue of telling somebody and what happens when you do tell somebody and who should you tell, blah, blah, blah. Megan.
Thank you, Barbara. Many of the people who responded to our survey weren't people who were being abused, but rather people who were in the position of being told about an abusive situation, or at the very least a disrespectful caregiving scenario. Depending on the circumstances, obviously, there are situations where you may be obligated to report, depending on your employment or the situation that you're in order to maintain the safety of other people. So a person might choose not to tell anyone, given all the challenges that Barbara just talked about, a family member or a friend, the actual manager of the organization, or a professional like a speech and language pathologist or an OT, their doctor, or the police, or a legal professional if they have access to either of those, even though that's somewhat of a rare circumstances. So given all the challenges that Barbara just outlined, it can be a difficult position to be in to try and figure out what the next steps need to be in order to help the person who's disclosed this to you. So when you're reporting abuse to a healthcare provider, it's not the same as reporting it to a friend, for example. So healthcare providers may be obligated to report the abuse to a third party, depending on the circumstances. They also are going to have to chart and write down their interactions that they have with patients. And for both patients and providers, this can be very difficult to navigate if the patient wants this information kept secret or wants to restrict who has access to this information. And the reason why I put this slide first is I think that you can be transparent with patients very early on in your interactions about your obligations if you're a healthcare provider. So, for example, I know that many psychologists who provide counseling to children will say your information is going to be put in a chart and I'll keep it private unless I believe that you or someone else could be hurt, and then I might have to tell other people to try and keep everyone safe. So anytime you have frequent interactions with one patient or intimate questions that you're asking in your practice or long-standing relationships, you can be proactive and transparent if you understand the legislation specific to your patient population and workplace, so that you're being as transparent as possible with people right from the beginning of your interactions about what your obligations might be if they disclose something of that sort of nature. And again, I think it bears repeating to remind people after they've made a disclosure what your obligations are in that setting. If you're not sure of what your obligations are, you can call your college, your professional college that regulates you, to get assistance. And they do typically respond quite quickly when you have a concern of this kind of nature, where you're trying to balance out someone's privacy and confidentiality with concerns about safety, especially safety for the general public, because if it's in a scenario where the abuser is paid to provide services to care for people, your patient is likely not the only person that they are providing care for, and it may be a danger to other people as well, not just the patient that's disclosed to you. There are also things that you can do to ensure that the information that you disclose is kept confidential within the care team. So I've seen this happen with mental health diagnoses, where someone may not want everyone involved in their care to know about their mental health history. You can put a lock on information, and your health records department will understand how to do this so that not everyone can access all of the information in the chart if that's something that the patient wants. So you can inform them of their right to sort of limit the disclosure to what you're legally obligated to do or ethically obligated to do. So within the legislation about the Personal Health Information Act, a health information custodian may disclose personal health information about an individual if they believe there's reasonable grounds that the disclosure is necessary for the purpose of eliminating or reducing significant risk of bodily harm to a person or group of persons. And I think this is relevant in a circumstance where, as I mentioned, the person who's being accused of the abuse has access to many different people who may be vulnerable. You would have to consider whether or not a disclosure from a patient in that sort of setting would be something that you might be obligated to report because of the danger to other people. So obviously, aside from your legal obligations, your first and foremost concern is always going to be about the safety and well-being of that person. So that means, depending on what they're disclosing to you, what what safety precautions can be taken immediately. So, is this person working in the next 24 hours, 48 hours, this week? When are they likely to come in contact with this person next? And does anything need to happen immediately to secure the safety of your patient? So I think if you get a disclosure of this kind, it would be smart to think you're going to probably cancel your next appointments in order to properly figure out a plan with this person as to how to move forward with this type of disclosure. So Barbara mentioned that it's very difficult to find shelters, and that is true, that have the services attached. It's not impossible depending on the person's care needs, but it is quite difficult depending on the specific community. There are a few, but very, very few in Ontario. So there's the idea of maybe asking about family members, places that they can stay, what kind of social supports they have, and additionally, sort of asking about how quickly this disclosure needs to be made if they do need to make a disclosure to the manager and take this person off of duty, as we're going to talk about in a bit. So the next thing is to really be as transparent as possible and be as respectful as possible about the person's wishes and what they want to do next. Given all of the barriers that Barbara has discussed, you really want to go through the different options that they have about what they could do next if they wanted to take this further. And really listen to what their fears are and what parts of those fears you can address and what parts of those fears are a legitimate part of trying to make this disclosure or trying to move forward with this. And you do have to explain, again, like I said, any obligations that you have to report as a professional, if that's the scenario you're in, and try to be as clear as possible about how far the information will go and to whom specifically it will go and what you are writing down and what you are going to say. I think it's fair to show people your charting notes and be really clear on exactly what you're charting, be really clear on exactly what reporting bodies you would report to, and how you can limit your disclosure as much as possible, like using tools like the lockbox. So you can also be honest if you don't know if you have an obligation in that moment. If you're frantically thinking, is this something that I legally am obligated to do something about ASAP, and this client doesn't want me to do something about it, I think you can disclose that to the client themselves. And I think you can make a phone call to your professional college, step out of the room for a moment if you need to, and get clarification as to what you need to do. If you're a member of a professional association, oftentimes that comes with access to free legal counsel. That might be one option. And additionally, you can talk to your employer in advance of these circumstances to really get clarification about any obligations you have in that particular setting. So as Barbara said, we know that people with speech and language disabilities are more likely to experience abuse. So if you know already that you're working with a population that's more likely to have this sort of experience, it's best to be prepared. So in terms of mandatory reporting and legislation, if you are aware of a circumstance where a child or a young person under the age of 16 is in an abusive situation, you are mandated and obligated to report to the Children's Aid Society. And when they become involved, they typically work with the families to create a safety plan. They work to identify sometimes alternative care providers within the family. Rarely they'll go to a foster care scenario, although I have seen that. But they do actually do a thorough investigation to see what the circumstances surrounding the disclosure were, and follow up with the family quite closely. The other option would be if it's abuse from a regulated healthcare provider. Again, you are obligated to report that to the college of the provider, and any criminal acts should obviously be reported to the police as well. If it's a doctor, for example, and someone's disclosing that their doctor has sexually abused them, then you do need to report to that college. I have heard of circumstances where the person did not want the person to disclose to the college, the patient, and they were allowed to make an anonymous disclosure, for example. The last example would be long-term care facilities. Any reported abuse or suspicion of abuse has to be reported to the long-term care facility action line. And although it's not on here, there's legislation within the developmental services sector that if you're an employee of one of the agencies under that act, you are obligated as well to report to the police any suspicion of that. So in terms of what your reporting options are, other than the mandatory ones that I talked about, for adults, if you suspect that someone who is being abused and does not have the capacity to understand their circumstance, you can report to the Ontario Public Guardian and Trustee, or OPGT. And that is simply an agency that will look into the abuse, and it's not a penalty to you to disclose confidential information if you have reasonable grounds to suspect abuse or neglect in a person who doesn't have capacity. So sometimes people will report financial abuse for elderly people by their sons and daughters. There's a lot of different circumstances that it's typically used for the elderly in terms of the scenarios that I've heard of where people have contacted OPGD, but it is an option. Obviously, you can report criminal acts to the police, but again, I think you have to be very respectful of what the person's wishes are and how that's going to play out in their lives when you do that. It needs to be something that's as collaborative as possible and ideally as consensual as possible. And lastly, you can report to the service provider. Ideally, the service provider should focus on the safety of that person and the safety of other staff and residents, and stop the accused from working with the person. If the abuse is criminal, they should call the police and not really do the investigative part themselves, typically. But once that's underway, they should obviously be looking at their own policies as to how they handle these sort of circumstances and following their procedures from there. Again, this can be a very tough circumstance for people to be stuck in. So I'm going to pass it to you, Pam, to talk about how the court systems work.
Thank you, Megan. I'm going to talk about reporting to the police, particularly from the perspective of the report being made by the person who's had the harm done to them. Because even though, as Megan has said, there are situations where you may have a duty to report to the police, or the service provider at an institutional level may have a duty to report to the police are going to take a statement at some point from the potential victim of the crime, because without the evidence coming directly from that person, it's going to be very difficult for the police to move ahead and decide whether or not they should be laying a charge and whether the charge will end up being prosecuted by the Crown and so on. So, although the initial contact with the police may have come from a service provider, either the individual or the institution, I'm now looking at the point in the process where the victim of the harm is making a statement to the police. You can provide support through this by helping that person get ready for their statement to the police. You can, for instance, let them know whether or not the police service in your area has a disability or accessibility unit. Some police services have it, not all, but that's something that you might want to find out about your own community, because if they do have one, then you want to encourage the patient, the client, to make an appointment with somebody who's in that unit. It's really important that the person bring someone they trust and or ask for a communication intermediary when they are coming to have their first appointment or interview with the police. So a couple of tips here. If you are trying to find out whether your police service has a disability or accessibility unit, You could talk to the staff sergeant or the police liaison officer. That's somebody who'd be able to give you that information. If you're talking to a client or a patient and suggesting that they bring someone they trust, you might want to make some suggestions to them about who that person could be. Obviously, it shouldn't be the person who's behaved in an abusive way towards them, and it should be someone who will respect that individual's privacy. And this is always a bit of a challenge because very often, whether it's somebody with a speech and language disability, another disability, or who isn't dealing with a disability at this time, automatically turn to family members as the person they want to bring because they trust them. Fair enough. But they need to think that through carefully. Is this a family member who's going to blab about this story to everybody over Thanksgiving dinner? Well, then maybe that's not the right person to bring. So you're not just staying away from the person who's engaged in the abusive behavior, but you want to stay away from friends or family members who don't understand that the individual is going to want a fair amount of privacy around this experience. That initial interview with the police may be videotaped. This practice varies somewhat from location to location, although now the police are getting more and more consistent about videotaping. It's not a really dramatic experience, but it can be intimidating to a victim because they're put in a room with a police officer and there's a video camera. They cannot bring a support person into the room, but they can bring in, and in fact, it's their right to bring in a communication intermediary. It's very important for the person to take their time in this interview, not to feel rushed or pressured by the police officer. Sometimes there is a bit of that attitude. This person should take as much time as they need, and if they're working with a communication intermediary, they need to have enough time so that that person can play their role. Once the interview is recorded, it will also be written down, and the person then has an opportunity to read it, and they're asked to sign it. The person should review it very carefully before they sign it. They can, of course, change it. They can add to it later, but it's more effective later on if the case ends up going to a trial if that initial statement is as accurate and complete as it possibly can be. The police will also collect evidence from other people who are usually called witnesses, someone who may have observed what happened, somebody who has knowledge about the circumstances within which the abusive events took place, and so on. If the police determine that the abuse is a crime, they will lay charges. And as Barbara said earlier when she was walking you through the slide that looked at different kinds of abuse, in Canada, the spectrum of activities that constitute criminal abuse is a pretty narrow one. There's lots and lots of emotional and psychological abuse that doesn't result in any kind of a criminal charge being laid. It is the police who decide whether or not to lay a charge. It is not the victim of the crime. And so once the person has gone and given their statement to the police, they're essentially handing over to the police all of the authority to decide what's going to happen next. The police will decide to lay a charge. The victim can't say, oh, a week later, oh, I changed my mind, I want you to withdraw that charge. And if the police decide not to lay a charge, there's not a whole lot that the victim can do to get them to lay a charge. Now I'm going to see if I remember. Oh, I do remember how to do that. So it's probably helpful for you to know who some of the major players are in the criminal process, because hopefully not too many of you have had to be involved with criminal law in your own lives. Many courts have somebody called a court accessibility coordinator. So if this situation moves ahead, the abusive person is criminally charged, the case is turned over to the prosecuting lawyer. I'll talk about that person in a minute, and it's going to go to a trial. The victim is going to have to testify. Their evidence is often the only evidence, or at least the major evidence that comes in front of the court. And if they need any kind of accessibility, they need to connect with the court accessibility coordinator. This is something that the communication intermediary can assist with, but you might be in a position where you're also providing some level of support to this person, and you might want to let them know that there is such a coordinator to help out. The Crown Attorney, that's the word that's used in Canada to describe the lawyer who prosecutes the case. In the United States, for those of you who watch Law and Order, this is the same position as the district attorney, more or less. So the Crown Attorney is the person who is acting on behalf of the country, the state, if you will, to say, this accused person, we believe they've done this. Here's the evidence that we have to show that they did it. And then the defense lawyer, of course, makes the other argument, and then a decision is made. One thing that people often don't understand is that the Crown Attorney is not the victim's lawyer. In Canada, victims of crime do not have lawyers during the case. They are not considered parties to the criminal case. They are simply there to be a witness to a case that's really about the accused person. So while the Crown Attorney is most of the time more or less on the side of the victim, they're not the victim's lawyer. They can't give that victim legal advice, and there's no relationship of confidentiality between the Crown Attorney and the victim. So anything the victim tells the Crown Attorney could well end up being shared with the defense lawyer. The defense lawyer is the person who represents the accused person. This might be a lawyer that the accused person is paying for themselves, or they may have obtained financial assistance in Ontario through Legal Aid Ontario to cover the costs of that lawyer. And it's that lawyer's job to poke holes in whatever evidence the Crown Attorney is presenting. So, for example, if the Crown Attorney has evidence that this particular abuse happened on a certain date, and the defense lawyer has evidence that the accused person was in a different city on that date, the defense lawyer would bring evidence to show that. The judge, I think we all know who the judge is. The judge is the person who, in most cases, makes the decision about whether or not the accused person is guilty. Sometimes there are juries, although those are rare trials. In that case, the judge gives instructions to the jury, and the jury then makes the decision about whether or not the accused person is guilty. Whether there's a judge only or a judge and jury, if the accused person is found guilty in Canada, it is the judge who decides on what is the appropriate sentence. I know in the United States, and I know lots of us watch American television, which is why I'm mentioning this, in the United States, often it's the jury that will decide on the penalty. That's not the way it works in Canada. Ontario has some support for victims who become witnesses in a criminal trial. This is called the Victim Witness Assistance Program. The worker is the Victim Witness Assistance worker. Other provinces have similar kinds of positions. They all have different names. This person works for the Crown Attorney's office. They're part of the court staff, if you will, and they can help the victim, who's now called a witness, by taking them to the courtroom ahead of time so they can see where all the different people are going to sit, by explaining how the process will work. If the victim needs to speak with the Crown Attorney, the Victim Witness Assistance worker will facilitate that meeting. They can accompany the victim witness to court, help them with some safety planning, refer them to community services, and so on. So they're a pretty important person. In some trials, there may be an expert witness called. This is somebody who, because of their professional expertise, has some knowledge that the court thinks will be helpful in getting to the truth of what might have happened in the particular case that led to the charge being laid. So I know Barbara has been an expert witness from time to time. There can be an expert witness about something like a speech and language disability. There could be an expert witness about almost any aspect that could come up in the case. And then, of course, a significant, very important player is the communication intermediary, who is there to assist the victim witness with a speech and language disability and the communication both by that person to the court and by the court to make sure that the person with the speech and language disability is fully understanding everything that's being said. So those are the main people that somebody would encounter if they were involved in a criminal trial. Very briefly, what happens? What are the steps in a criminal case? It looks nice and tidy here on this page, but I can tell you it's neither tidy nor quick. The first step after the person who it's alleged has done harm, has done a bad thing, Once that person is charged, the police hand their file over to the Crown Attorney, and the police really aren't involved with the case anymore. They may come and provide evidence during the trial, but now the case is in the hands of the Crown Attorney. And the next step is for a bail hearing. A bail hearing determines whether or not the accused person is allowed to be out of jail up until the time of the trial. In Canada, most of the time, accused people are released from custody. We simply couldn't keep everybody who's been charged with a crime in jail, but also those people haven't been found guilty yet. So where there is little risk that they will flee the jurisdiction, where they have some stability in the community, perhaps a job to go to, they own a house, they have family members there, they're probably going to be released from custody. They will have conditions placed on their actions. In particular, they will be told they cannot have contact with the victim or witness. They can't phone them, they can't write to them, they can't sit outside their house and stare through their window, they can't send their brother over to talk to the victim witness, and so on. But there may be other conditions as well. For instance, depending on the facts of the case, there could be a curfew, there could be a requirement that they not consume alcohol. They may be told to stay away from certain locations. That could come up if the offense took place, let's say, in a healthcare setting, in a long-term care facility. They might be banned from being in there until the trial is over. Once the bail hearing has taken place and whether or not the accused has been released from custody, the next step is what's called disclosure, and this is where the Crown provides the Crown Attorney provides the defense lawyer with all the evidence that the Crown Attorney has. So the statement of the victim, the statements of any other witnesses, any police officer statement, physical evidence, perhaps there were injuries, perhaps some furniture got broken. All of that evidence is given by the Crown Attorney to the defense lawyer. That's the law. That is required. Then things really slow down because a series of meetings will take place. Officially they're called Crown resolution meetings. They're what most of us would think of as plea bargaining. The defense lawyer and the Crown Attorney meet. They talk about the evidence. Each of them talks about how strong they think their case would be, where they think there might be weaknesses in their case. So for instance, where the victim witness is somebody with a speech and language disability, the Crown Attorney might be very concerned that that person will not be able to testify in a convincing and compelling manner. And so the goal of these meetings is to try to resolve the issues without having to go to a trial. Perhaps what happens is that the accused has initially been charged with aggravated sexual assault, and maybe on the basis of the facts, that's actually what the person is guilty of, if you want to put it that way. But if the Crown resolution process goes in a direction where the Crown isn't comfortable with the witness, perhaps what will happen is the charge will be reduced to a simple sexual assault charge or even an assault charge if the accused person agrees to plead guilty to that. So that's why it's called plea bargaining. Everybody's trying to wheel and deal back and forth, and both lawyers, the Crown Attorney in particular, have the goal of trying to keep the case from going to a trial, to come up with an outcome that everybody can live with. Unfortunately, as you can tell from what I've said, there's one person who's not in the room there, and that's the victim. So often the victim feels as though this whole thing happened without them having a chance to have a voice in that proceeding, and people can be very upset, especially if the charge is dropped or it's reduced to a very minor charge or there's almost no penalty. If that Crown resolution process is not successful, the case will eventually make its way to a trial. Here is where, this is what we see on TV and in movies. It's heard in a courtroom, either by a judge alone or with a jury, as I mentioned a few minutes ago. The Crown Attorney must prove the case beyond a reasonable doubt. What that means is that the Crown has to convince the judge or the jury, basically, that it's 99.9% for sure that the person who is accused of this crime did what they have been charged with doing. It's a very high standard of proof. The victim witness often testifies, I would say almost always testifies, and will be cross-examined. So after the Crown Attorney asks the victim witness the questions about what happened, and that's hard. That's really hard to stand or sit in a courtroom and talk about something very personal that's happened to you even when the person asking the questions is the Crown Attorney who's on your side. But then the defense lawyer gets to ask the victim witness questions as well. That's called cross-examination. And that is very, very difficult, very challenging for anybody who's been the victim of any kind of crime, because the job of the defense lawyer is to try to make it look as though the victim is lying, has a bad memory, has forgotten important details, and so on. After all of the evidence is in, whatever other witnesses may testify, each lawyer, the Crown Attorney, and the defense lawyer sum up their case and make their argument to the judge or to the jury, and then we have the verdict, where the judge or the jury determines whether or not this individual is guilty of the charge that they've been facing. Then there's another phase in the process. We're almost done, don't worry. And that is determining the appropriate sentence. At this point, the victim has the right in Canada to write what's called a victim impact statement, where they can talk not about what penalty they think the accused should face, but about the impact that this crime has had on them, that they've become more fearful, that they're having a sleep disorder, they're not able to eat, they haven't been able to go back to their school, whatever it is. The accused will probably go through a process that's called a pre-sentencing report to look at what's an appropriate penalty for this particular accused. Then the judge will determine the sentence. It could be a jail term, it could be probation, it could be a discharge. Discharges can be either absolute or conditional, and what that means is that either right away in the case of an absolute discharge, or after the accused has done certain things in the case of a conditional discharge, they don't have a criminal record. And so, of course, that's a goal that many defense lawyers are working towards with respect to their client, so that the client can walk away even if they've done something wrong and not have a criminal record. So over to you, Barbara, I think.
Thank you, Pamela. I'm always fascinated by what you have to say. And I just wish we had more stories of people who have speech and language disabilities going through that process. But
yeah, I do too.
I do know of some, but incredibly difficult to hear the stories and to collect them and use them within our trainings and webinars, because very few even get to the point of disclosing to police. I always feel that if you can get to the police, have to believe you and be able to disclose, then perhaps the door to the courts will open up, but they don't even get that far. But
you're absolutely right.
That's fascinating. I want to talk a little bit about communication supports and accommodations for people with speech and language disabilities in accessing the justice service. I think we can safely say that the service is not accessible right now in Canada. And there is no service in Canada, it's provincial. The justice systems are operated on a provincial level. And there is no mandate right now. There's no obligation or directive that tells courts or police that they must provide communication accommodations for people who have speech and language disabilities. And we're up against that. We have a situation where we're trying to educate the justice sector about this population. And in trying to do that, we've moved along and said, look, we're going to put communication intermediaries in place so that we'll give you somebody to connect with when we tell you about the needs. It's a very complicated puzzle, and there's so many bits and pieces to it, and we've got some of the pieces but we haven't connected them just yet. We desperately need education and a directive within justice services that actually tell them that they must have a protocol that provides communication accommodation supports for this population. And that can be somebody to assist a person to communicate with them. So a trusted person. We're not saying it has to be an intermediary or a professional in all situations, but it could be a trusted person that the victim witness identifies as somebody that they want to assist them, as Pam said. In many cases, however, there is a need for an impartial, professional assistance. And that's what we're calling a communication intermediary. Now, we are at this point, and Cindy, I see your question there, can anyone be a communication intermediary? I think anyone could be a communication assistant. But when the courts are asking for a professional intermediary, and because we don't have an accreditation process on right now, we're saying they have to be a speech pathologist. We have to cover our bases. We know at least that speech pathologists have so many years and are qualified to be in communication disabilities and should know what their level of expertise is and should be working within the ethics of their regulatory college. And that means that if they have no experience in augmentative communication, they should state that up front and not provide that assistance, but refer the police or the justice professional to somebody who can provide that. So we're working with a group that is regulated, that does have base qualifications. And what we're doing is we're providing extra training to speech language pathologists so that they have some idea about their new role working as an intermediary. And working as an intermediary within the justice system is a different role than working as a clinician or an AAC clinician in a clinic. And I'll explain that in a minute. You've got to know something about the justice system. You've got to know your boundaries and what's allowed and what's not allowed. So that's what we're doing. When we talk about intermediaries, we're creating basically the equivalent of what the justice system now has in terms of specialized sign language interpreters for people who are deaf or hearing loss, who are accessing justice, and the same for deaf blind. We're saying here, you got to have more skills and you got to have professionals come in to help out in some situations. So the role of an intermediary then is to assist in two-way communication, to assist with effective communication, both expression and comprehension between what we call the end user, that being the police or the justice professional, and the person with a speech and language disability. And we're saying what the intermediary should be able to do is assist the person to understand questions and what is asked. Pamela just talked about cross-examinations. Cross-examinations are all about complex language, leading questions, tripping people up and using language to do that. Incredibly complex for anyone, regardless of whether they have a speech and language disability, much more complex for the population that we support. So the communication intermediary assists with this and will provide information to the justice professionals as to how the person can respond to leading questions, in the sense that they'll always say yes, they'll always agree with you, they won't understand that, you'll need to phrase it this way. All of that, giving that information up front. They don't have any time concept, so it needs to be personalized. I need to give them pictures to support them around time. I need to give them a calendar. But basing that on evidence of a language comprehension assessment that is credible on that, and that they're credible enough, are qualified to speak to. So assisting the person to communicate their message expressively as accurately, completely, and authentically as possible. That's very, very loaded, isn't it? So you want validating a person's meaning, echoing what they're saying, sometimes reformulating, say, do you mean this? Do you mean that? So validating what they're meaning, making sure that they are able to get their full message across, and without being interrupted. And many of us know that that's a big issue. And authentically, here we're talking about authorship. So it's not somebody else saying, he's saying this, but absolutely showing the transparency that this person is directing the communication at all times. So one of the things we say is that an intermediary never works alone. They are always in front of the end user, be it the police or the justice professional. They don't go away into another room and report back what the person says. That's not what they, much more in the line of an interpreter, but even more than interpreter, sort of a cross between an interpreter and an expert witness. And that's something that we're working on right now, that definition of an intermediary to assist the justice sector know where they fit. An intermediary would assist the person to use their preferred methods of communication. So again, this is the person wants to use their display, their device, and not be controlled by yes, no questions or whatever. That would be facilitated. To express their experiences, intentions, and desires. To read and understand documents if they needed assistance in that, and to sign and complete forms. So looking at comprehension expression in face-to-face communication, as well as reading and writing. And what an intermediary does, and when we do our training, we talk about this. We talk about, first of all, doing an assessment and determining what the accommodations and supports are for this person. The person may, an accommodation might be, this person needs vocabulary. They need pictures to be able to express what they want to say. And then we have very strict guidelines on how you introduce pictures and vocabulary. I was once accused of putting words in somebody's mouth because I gave the person a number of pictures to express what had happened to him. And I was able to say, but I gave him 30 pictures and he only used a certain number, 3 or 4, consistently. There are procedures that we suggest about how to do that. We would never program vocabulary into a device. We keep new vocabulary separate from core vocabulary. That's all part of what we do when we do communication intermediary trainings for speech pathologists. The intermediary then might do the assessment, determine this is what this person needs. Then they would write a report that explains, here's how the person communicates, these are the recommendations. And they may recommend things like, you know, you've got to be wary about comprehension for this, you've got to give the person more time, blah, blah, blah. And one of the recommendations, and typically is the recommendation, is that this person needs direct assistance. And so it's up to the end user then, on the judge, to decide whether they will allow an intermediary to come into the court. So this is the point where we're saying, here's the need. But the need doesn't necessarily mean that you're walking into to the court to assist somebody. We have 195 communication intermediaries. Some of them are on this webinar. It's nice to see that. And we've got people in every province in Canada. We do not have enough of them, obviously. We have 73 registered for our September trainings. I'm delighted with that. And we do 3 webinars. We talk about the role of the webinar. We give people standards of practice. We give them guidelines, code of ethics, and guidelines on working with in the justice system. I want to be very, very clear. We don't accredit. So people do not work for CDAC. We would love to accredit. We think we should be accrediting communication intermediaries. In the UK, where they have adequate funding, they have a wonderful program called the Witness Intermediary Scheme. Speech pathologists are one of the professional groups that they train, and most of the intermediary work is done by speech pathologists in the UK. But they accredit them, and it's a weeks-long training. They do assignments. They are put in a situation where they have to do an interview and support somebody, and then they're accredited. As I say, we struggle in Canada to get some funding to get this thing going. And that's where we're at right now. And our feeling is better to build something than nothing. And so that's where we're starting this point. But we keep lobbying for more. This is, you can see our roster on our website. People with speech and language disabilities need to request an intermediary. If So give them the link and information. I think that's really important. You can download a brochure. Um, it's ironic, but how it works in Ontario is you have to ask the court accessibility coordinator for accommodations, which is sort of crazy if your disability is speech and language disability and the court coordinator has no training in how to communicate with you. However, we as speech pathologists, as people who support people with speech and language disabilities, please download the brochure, give it to people. There is the website is on it, and suggest that if they ever need this, if they do need to communicate with police or courts, give it to them so that they can follow up and read about where they can get an intermediary. Pam and I wrote guidelines for the justice sector, for police, the legal and justice sector, on how to use an intermediary, and they're on the website. You can download them, but they can't just be on the website. Let's make sure that people with speech and language disabilities and families know where to find this information when they need it. Meanwhile, we will be advocating to do more education for the end users, as well as to develop more communication intermediaries on the roster. And we're also advocating right now, hoping to get funding to do what's called a legal memorandum, which will help the justice sector know where to place intermediaries within their service and maybe lead to a directive for that. These services are new. So yes, there were 53 inquiries over the last 6 months. Not all of them were about criminal justice. Some were other like municipal courts, civil courts. Some of them were questions about, is this needed? Some of them were about consent to capacity and using intermediaries in another way. So we're just getting started with it. Payment for services. We would argue that service providers and the courts and the police, they must provide, and they're familiar with providing translation services and for funding sign language interpreters when needed. And we feel that this must be dealt with in the same way to pay for the intermediary support. And that they're the guidelines. We also have on our website vocabulary that people can just download and use. And there's 16 different communication boards around abuse. This one on the slide is about emotional abuse. There's ones on sexual abuse and physical abuse. And if you do need, they don't have everything, but it's a good place to start a conversation and to have them available and give them again to people who need them, or program the words into devices. There's also links to other resources, resources that we've developed and international resources. Wonderful resources from the UK, lovely videos that they have developed. If you're into this, I'd certainly refer you to our website and you can get more there. So we've come to the end of our webinar. And in summary, I would say important again, people know their rights, their service rights. It all links back to our very first webinar, accommodations and supports, access to goods and services. That's our argument. The legislation is there that say we must make services accessible. When we talk about making legal and justice services accessible, this is the way to go with it. At least this is how we feel we should be going with it. Helping people communicate about their rights, communicating about abuse and crimes, and having the tools and vocabularies and knowing their options, as Megan covered from the start, knowing about what happens depending on who you tell, very complex. I need to study it before I told anybody, but it's complex. And go back to that original thing, make sure that people have a card that tells people, no matter who they are, I have a speech and language disability. Here are the things I need you to do so I can access your service. And lots of ideas on our website and our toolkit for that. So we've come to the end of our legal webinar series. We're going to be sending you out the handouts from today and a survey. Please go on the survey, give us your feedback. I know it's a difficult thing to remember and to do, but we really appreciate it, particularly as we beg for more money to deliver useful information. And we'd like to know if this is useful for you. Cindy saying, thanks, good to hear about the efforts of Rita's work. Okay, great. Anyone got any quick questions and comments before we all run for dinner and a glass of wine, I hope? You're welcome, Elaine. Okay. If everybody's okay with everything.
Thanks,
Okay.
Barbara. Have a good
Thank,
night.
thank you
Thanks,
all.
everybody.
Yeah.
Megan. Thank you so much, Pamela, for joining us. And I wish you all a good evening. And this will be on our website next week.
Great. Take care.
Talk soon. Bye.